Hello, wherever you're watching from. Hello to you, and welcome. I am so pleased to welcome you to our very important broadcast today. Permit me to say good morning, good afternoon, good evening, and good night to you, depending on your time zone. Wherever you're watching from, you are all welcome. It is an interesting piece of information and news item that we have today. The Director General of the Department of State Security Services, DSS, Yusuf Bichi, is at the risk of being jailed for disobeying court orders incessantly. It has become so notorious with the very Department of State Security Services, not under this particular Director General. The previous Director General, since the case of Nnamdi Kanu started, they have flouted court orders that were in the favor of Nnamdi Kanu all the way from 2015 up until today. Today, there is a new Director General under the administration of Bola Ahmed Tinubu. His name is Yusuf Bichi. He is not from the Southeast. He's not from the South. I don't want to talk about ethnicity here in this very broadcast. We want to look at the facts and we want to talk about what his action of disobeying court orders, what is the consequences of that? That is exactly what we're going to be talking about. Biafra, Gel DSS DG, Gel DSS, the Director General of Department of State Security Services, Yusuf Bichi, for disobeying orders, for disobeying court orders. Nnamdi Kanu asked court. So this very approach or this very legal move of Maz Nnamdi Kanu via his legal team, is it in order? Is it in order? Is it in place? Is it worth it to approach the of competent jurisdiction to seek for the conviction, to seek to jail the Director General of the Department of State Security Services, Yusuf Bichi, for flouting court orders? He is supposed to be a contaminor. That is what he's supposed to be according to the law. He is supposed to be committed to prison. He is supposed to be jailed for flouting court orders. When court issues orders, it is binding. Any order of the court that is issued is binding except you choose to challenge it in a court of competent jurisdiction. If you don't challenge such an order of a lower court at the higher court, it is binding, except you go to the higher court to challenge that very order that was given by the lower court. In this instance, the federal high court is a higher court than the state high court. Now, when you come to the federal level, the way that the judiciary is constituted or put together, you have the federal high court. The federal high court is lower to the appeal court, federal appeal court, or court of appeal. You have state court of appeal, you have the federal court of appeal. Now, the case of Nnamdi Kanu is not a state case. It's not under the state level. It is under the federal level. So he's been tried at the Federal High Court, the courtroom of Justice Bintu Nyako. Now, that very Federal High Court of Justice Bintu Nyako is lower to the appeal court, which is federal. Now, the appeal court and the Federal High Court is lower to the Supreme Court. That is the hierarchy of judiciary, how it is put in place to ensure justice at different levels. It's not everything you will run to the appeal court. The appeal court is the appellate court. That is where you go to appeal a judgment or a court order that was given at the federal high court, which is considered a lower court to the appeal court, to the appellate court. I hope you understand that. So, and it's not every matter you rush to the Supreme Court. You must go through the stages of litigation, starting from the high court to the appeal court before you can now take the matter to the Supreme Court if you are not satisfied with the ruling of the federal court or the federal high court or the appeal court. before you now go to the apex court, which is the Supreme Court, being the highest court in the land. So any order that is issued at a federal level, being the Federal High Court, any directive of the court becomes binding on the people who are expected to carry out or to implement or to comply with such directive of the court. In this instance, Department of State Security Services, the court orders that are in the favor of Mazen Nnamdi Kanu regarding it is so many orders that have been given regarding to allow his visitors access to him upon the days that the court has provided or directed for his visitation to take place. You must allow them access to have fruitful and unfettered access or conversation with him without being bugged or their privacies being breached. That is one of the court orders. Another one is that you must allow his legal team to have access with him, to consult with him upon their visitation or their visiting days. They are supposed to have unfettered access to him, to discuss with him, to look into his case, to prepare him for defense of his case. This is according to the Constitution. So such orders were given to the detaining authority where Mazen Nnamdi Kanu has been detained for the past 3 years. They have broken and flouted those orders of court. Court had issued orders to allow him to change his clothes. They have flouted that very order of court. Court had directed that you must allow him his reading glasses, which they took away from him upon his kidnap from Kenya to Nigeria, which is called extraordinary rendition. His reading glasses, his glasses were seized till today. The glasses had not been returned to him. His Torah, being the Old Testament that he normally read, because he believed in the word of God. He is a child of God, he is a prophet of God. They took it away from him. They have not returned his Torah to him. Court had ruled on in that very regard to return his Torah to him, to return his reading glasses to him. They took away his talit, which is the prayer shawl. You know, that very, I don't know how to describe it, but you know what is talit, that the Jews cross over their neck, their shoulder. Sometimes they use it to cover their head during prayer. It is called a prayer shawl or talit. They took it away from him. They have not returned it to him. They took away his laptop. They took away his phone. All the orders that court has given, several orders, including his medication, including access to his personal doctors and physicians. They have all flouted all the court orders that were issued in the favor of Mazen Nnamdi Kanu. And at this very point, Mazen Nnamdi Kanu could not contain it anymore. The legal team were directed to approach the court to seek for the imprisonment of the Director General of the State Department of State Security Services, DSS, in the person of Yusuf Bichi, for flouting the court orders, because it is on his table, it is his prerogative. He is duty bound as the director of that very department, as the director of that very institution, of that very force, to direct the personnel, the members of that very operative, to ensure the compliance with and the implementation to the letter of these several court orders regarding how Nnamdi Kanu should be treated, regarding how his visitors should be treated, regarding their actions and approaches when it comes to handling the case of Nnamdi Kanu in their custody right there at the headquarters of the State Department or Department of State Security Services in Abuja, Nigeria. So this is why the legal team of Mazen Nnamdi Kanu decided to approach the court to seek redress, to seek for the committal of this very DG of DSS, his committal to prison. When you flout court orders, you risk jail term. When you flout court orders, just like when we read in the news yesterday that there is a court order describing the proscription of IPOB as illegal, as unconstitutional, as illegal. unconstitutional. We read it yesterday because some people have been going with that very tag. Oh, IPOB is a terrorist organization, proscribed terrorist organization. They cannot even be able to substantiate what qualifies IPOB as a terrorist organization. And there is no way in the world, nowhere in any democracy, even in the military regime, that you can proscribe indigenous people. Indigenous people. You cannot do it because these are the indigenous people. They are old in the land, older than the Constitution of Nigeria. The indigenous people in different hamlets and regions of the country of Nigeria, they are older than the Constitution of Nigeria, if you don't know. The law was made to guide the conduct of the people, to make sure that the society and the country is not a lawless state, that everyone is acting according to the law, what is deemed fit, what is supposed to be something that's supposed to be one of the best practices that is admissible by the culture of the people. And when it comes to democracy, the rule of law is the standard for everybody, regardless of the region or the tribe, or where that very region, whether it is Hausa, whether it is Yoruba, whether it is the Igbos, whether it is even those that are called the minorities. Everyone is equal before the law. So this very Department of State Security Services, DSS, the Director General is not an Igbo man, it's not a Yoruba man. I don't think he's a Yoruba man. Maybe, I don't actually know his ethnicity. He could be Hausa, he could be Middle Belt, because there is a combination of Hausa Middle Belt name there. Yusuf, we know that Yusuf is Hausa, we know that Yusuf is Fulani, and also some Yorubas, Oduduwas also goes by that very name, Yusuf. But Bichi is what I don't understand the ethnicity where it comes from. But that is not what we're discussing. As I said from the beginning of this very broadcast, we are looking at his conduct, and we're looking at the risk that his conduct is likely to take him into. That is your term. I am bringing to the screen this very piece of information that is very, very important. It is very, very important, and I think the court should consider it. The court should consider it. We were told, even in secondary, in secondary school, we are told that the judiciary is the hope of the common man. The judiciary is the hope of the common man. So if the judiciary cannot guarantee the hope and justice for the common man, it means that it has lost its essence and purpose of creation. It is one of the three arms of government. The judiciary is one of them. Very, very important. What is the duty of the judiciary? The duty of the judiciary is to ensure what is called checks and balances, to interpret the law. That is the duty of the judiciary, to interpret what the law says. We know in the three arms of government, the executive, the legislature, or the legislative, and the judiciary. The legislature makes the law, they enact the law, they pass the bill, and it becomes a law. And the judiciary interpret the law. The court, the judiciary, be it customary court, be it magistrate court, be it state high court, be it federal high court, be it appeal court, be it the Supreme Court, they are all branches of the judiciary. They are there to interpret the law, to tell the world, to tell the citizens, the litigants, and both the defendant and the appellant what the law actually says. That is their duty, to interpret it the way it is. And the executive is there to implement the law. But we see in Nigeria, in this type of democracy, that it is not actually a true democracy. It is not an ideal democracy. If it is, this man would have been in jail before now. Biafra, jail DSS DG Yusuf Bichi for disobeying orders, for disobeying court orders. Nnamdi Kanu asked court. This is the man, Yusuf Bichi, the Director General of the Department of State Security Services. This is the man, Yusuf Bichi, and this news item is coming from trackingtimes.co, trackingtimes.co. That is where this very news item is lifted from. Thank you for joining us once again. If you are just joining, I am Pastor Maxwell Nawehe. We are here to bring to you the information and the truth, to press home the need for all and sundry to comply with justice, all and sundry to comply with the very, very important aspect of the Word of God. Truth. Truth. Jesus says, I am the truth, the way and the life. I am the truth, the way and the life. No man comes to the Father but by me. Truth. John chapter 8 verse 32. You shall know the truth, and the truth shall set you free. You know the truth, and it's going to set you free. Why Nigeria is in this very quagmire, in this very dilemma, is because the leaders have decided to collectively and consistently run away from the truth, which is so obvious. They try to run away from it, but they cannot. The Director General of the Department of State Security Services, DSS, Yusuf Bichi, risks jail terms. Risks jail term as the leader of the indigenous people of Biafra, IPOB. Nnamdi Kanu has urged the Abuja Federal High Court to jail him over his refusal to adhere to several court rulings regarding his visitation by court-approved persons in DSS detention facility in Abuja, Nigeria. Yes, the Director General of the Department of State Security Services, DSS, Yusuf Bichi, risks jail term. He could possibly be jailed. He is at the risk of jail term. That is the truth. Jail term. Why? For refusing to adhere to several, not only one court ruling, not only 2 or 3, as I said earlier, several court rulings regarding his visitation by court-approved persons in DSS detention facility in Abuja, Nigeria. There are persons that the court had ruled that these persons, so and so persons, are free, are allowed to visit Mazi Nnamdi Kanu in the detention facility of the DSS in Abuja, Nigeria. Members of his family, his legal team members, or any other person that he wants to come and pay him a visit in that very facility. The court had ruled several times that such persons are allowed. They should be allowed by the DSS to visit Mazi Nnamdi Kanu, to have discussion with him, to have conversation with him, whatever it is that they want to do with him, they should be allowed to have access to him. But this very operative of Nigeria, which is like the Nigeria FBI, which is like the MI5, which is like the CIA, DSS, have flouted these very court orders several times, have flouted these very several court orders in this regard several times. And as a result, Mazi Nnamdi Kanu had to approach the court to seek for the committal of this man to prison. Recall that on May 20th, 2024, the Abuja Federal High Court had granted an order modifying the conditions of visitation to Kanu in the DSS detention facility. The court had ruled that an order is hereby made varying the condition of visitation to him in custody to 3 days a week. He is to be given a safe and clean room to be made available to the defendant at the present facility to prepare for his defense with his legal team of counsels or team of counsels, not exceeding 5 in number. Not exceeding 5 in number at the same time. So 5 of his legal team members, his counsel, or those that are supposed to visit him, 5 of them at once, not separately, not individually. They are supposed to meet with him at once. So if 5 of them had access to Nnamdi Kanu, it means they are going to be 6 in number during the time of their discussions or conversation. And this is supposed to happen 3 days in a week. 3 days. So out of 7 days of the week, 3 out of the 7 days of the week, such 5 persons are allowed to pay him a visit. This is the ruling. This is the order of the court. But this very operative has disobeyed this very order and other court orders that they should be allowed such a facility that is required for the preparation of his defense and be allowed to take notes. They should be allowed to take notes. In other words, they should go in with their writing materials. They should be able to write down certain things, certain points, certain area of their litigation or advocacy or their line of defense. They should be allowed with a biro, with their writing materials, to take notes in the process or during their conversation or discussion or visitation. Now, look at what happened. However, in a notice to the Abuja Federal High Court, Kanu's lead counsel, Aloy Ejimako, said the DSS Director General, Yusuf Bichi, had refused to comply with the orders of the court. Ejimako notified the court in a notice tagged "Notice to show cause why an order of committal should not be made" and forwarded to Daily Post on Monday. The notice, which had Bichi and the federal government as respondents, said despite serving the DSS boss, had refused to obey the orders despite being served. So this is the attachment of that very court order. This is the attachment of that very notice that the legal team of Nnamdi Kanu filed against Yusuf Bichi, the Director General of the Department of State Security Services. This is the attachment, the attached file. It is the notice. This is it. In the Federal High Court of Abuja, in the Federal High Court of Nigeria, in the Abuja Judicial Division, holding at Abuja, charge number FHC ABJ CR 383/2015, between Federal Republic of Nigeria complainant and first respondent and Nnamdi Kanu, defendant applicant Yusuf Bichi, Director General, State Security Services, which is SSS. Sometimes they are called DSS, which is a second respondent / conterminor. Motion on notice for committal brought pursuant to A, Section 72 of the Sheriffs and Civil Processes Act, B, Order Rule 13 of the Judgment Rules, Section 287, subsection 3 of the Constitution of the Federal Republic of Nigeria as amended, and B, under the inherent jurisdiction of this Honorable Court, take notice that this Honorable Court shall be moved on /day of -2024 at the hour of 9 o'clock in the forenoon or so soon thereafter as counsel may be heard on behalf of the defendant / applicant, praying this Honorable Court for the following. You can now see they follow it. An order of the Honorable Court committing the second respondent, contemnor, namely Yusuf Bichi, to prison, to commit him to prison, to jail him, to imprison him for contempt of the order entered on 20th May 2024 by Honorable Justice Binta Murtala Nyako. Secondly, and for such further or other orders as this Honorable Court may deem fit to make in the circumstances, dated this 10th day of June 2024. It is signed by, the lead counsel of the legal team of Nnamdi Kanu, Barrister Lloyd Mako, and the rest of them, Nemeka Ejiofor Esquire, Maxwell Opera Esquire, etc. So that is it. He should be committed to prison. That is what they are seeking for. That is what they are asking the court to do. That, however, an order is hereby made, varying the condition of visitation to him in custody to 3 days a week. He is to be given a safe and clean room to be made available to the defendant at the present facility to prepare for his defense with his team of counsel, not exceeding 5 in number. That they should allow such a facility, as required by the law for the preparation of the defense, and be allowed to take note which order you disobeyed as follows. On every visitation made to the applicant at the State Security Services Detention Facility Headquarters, Abuja, after the issuance and service of the said order and Form 48 thereof, you have not allowed applicant counsel to go in with writing materials to take notes of their discussions between the applicant Kant and his lawyers relating to the preparation of the applicant for his defense. You have not complied with the 3 days per week visitation to the applicant as was ordered by the court. Yusuf Bichi, you have not provided safe and clean room to the applicant at the present facility to prepare for his defense with his team of counsel. Yusuf Bichi, that you have not allowed such facility that is required for the preparation of the applicant's defense, which facility you have disallowed on every visitation since the said orders were entered as set out below. Now, this is it. Interdiction, seizure, perusal, and photocopying of legal documents relating to the trial preparation of the applicant is forbidden by the court order. Refusing certain visitors to the applicant, including those that are applicant's potential witnesses and or who possess information critical to the adequate preparation of the applicant's defense to the criminal charges pending against him, particularly as it pertains to cross-examination of prosecution witnesses and authentication / impeachment of prosecution's documentary evidence. By not retracing your steps after you were on 31st day of May 2024 served with a Form 48 notice of consequences of disobedience to court. Yusuf Bichi, by not retracing your steps after you were on the 31st day of May 2024 served with a Form 48 notice of consequences of disobedience to court, and take further notice that you are hereby required to attend the court on the first mentioned day to show cause why an order for your committal should not be made. This is the end of this very news piece, and you have to follow up, because this is what's supposed to happen in a Sinai clime. It's supposed to happen. If it is in the USA, this man should now be in prison. If it is in Britain, this man right now should have been in prison. If it is in China, I don't know if they would have decapitated his head. I don't know what that very punishment is by the Chinese law or constitution. But I know in developed societies and democracies, This will not allow to stand. This flagrant disobedience and flouting of court orders will not be allowed, cannot be allowed. So that is it. And with this, we are bringing this very segment of our broadcast to an end. And please, thank you for watching. Subscribe to this very channel here on Engine Speak. Subscribe to my channel on YouTube, Maxwell Nnawihi. Follow me on Facebook, Maxwell Nnawihi. Follow me on Twitter, X, Maxwell Nnawihi. Follow me on TikTok, Maxwell Nnawihi. Follow me on Instagram, Maxwell Nnawihi. Thank you very much. See you very soon with the next segment of our broadcast. Bye-bye.